Good morning. Time now is 9:04, and we're going to call the meeting of the quarterly meeting of the Board of Examiners of Surveyors to order. And let me read this quick notice. Notice of the October 23rd, 2014 meeting of the Board of Examiners for Land Surveyors posted to the Board of Examiners for Land Surveyors website on October 6th. 2014. And the first order of business, our agenda. I'd like to entertain a motion to accept the agenda as we have it.
Mr. Chairman, just real quick before we do that. It's not on the agenda, and I've passed out these paper versions of this notice, but if you'll recall, last time we were going to finalize this notice and get it ready to set a hearing.
Okay.
I'd like to sort of tack that on to well, wherever you want to take it on. I was thinking maybe after the director's report or before it, or whatever the pleasure of the board is. But if we can just get that in.
Okay. That'll be fine, and that'll be what is this? A notice of rulemaking. Is that what you had?
I gave you a paper copy so you can scribble on it.
That's good.
It's not on your
I need
laptop.
paper copies and scribbling. So,
So
all right. Well, we'll add that one to the agenda, and I guess right after the director's report will be fine. Is there anything else that we wanted to add to the agenda? That Tim, you sent me some information, and Jay, have y'all?
Yes, sir, Mr. Chairman. I'd like to add an item to discuss the recent EPS committee meeting that I attended in South Dakota last week. I'd like to give you all some update on where things stand about the exams and so forth.
We'll add that also to the agenda for a report. Is there anything else that we'd like to add to it? Mike, have anything from TAPS?
if you'll make sure that your little red light comes on so we can get you. There you go.
That way they can hear you and not wonder what was said confidentially. Like
Straight into it.
Look straight into the microphone. It'll work. Okay, with the addition of the two items to the agenda, I will now entertain a motion to accept the agenda as amended.
I'll make that motion to adopt the agenda as amended.
And a second.
Second.
All in favor?
Aye.
All right, thank you. All right, now that we've adopted the agenda, we need to review and approve the July 2014 meeting minutes.
I did have one question under the minutes. It fell under the topic of GIS photogrammetrist report, which I believe is on page 5. Donna, if you could turn over to page 5. Reading through it, it was a little bit confusing. I just want to make sure that the way we have it written is correct. Where he states there toward the end of his first sentence, where Mr. McDonough was giving a report, he says his committee was currently not in favor of licensing as they felt the public was not properly protected. That kind of seems to contradict each other there. I just want to make sure that was correct.
We'll have to go to the video and just double check.
Okay, yeah, if you would please, just want to double check that.
Okay. Anything else concerning that particular thing? We probably will have a further discussion on that sometime during today.
All right, if there's no other changes or amendments to make to the minutes, I move we approve.
Okay. Motion to approve the minutes as they have been presented. Here a second.
Second.
Any other discussion on it? Okay, all in favor?
Aye.
I would say opposed, but since everybody said aye, I don't guess I need to say opposed, do I? All right, and now that we go to the legal report. Mr. Legal,
Alrighty, let's see what page on the pad that is. Page 10.
Page 10.
Four cases here. If it pleases the board, you can either read them yourself and digest them that way, or I can read them to you. It's not necessary for me to read them to you. I mean, I can.
Won't you go through, because I personally, I like you to present that, and that way, as we read through, if we have a question, we pick it out probably quicker than we would if we were reading ourselves and just overlook it. Speed reading is not always the best thing here.
I know, I'm looking up a 820 here.
Alrighty, number 1 then. I think they're all new cases. Case number 2014-016351. This complaint was filed by a consumer who alleged that the respondent testified in court that the respondent did a survey for their neighbor's adjoining property, but did not do a plat and did not know if respondent was required to do a plat under Tennessee law. The complainant further alleges that the respondent removed existing nails while staking the property. The respondent states that the respondent was hired to stake a property line, and respondent states that any existing nails, stakes, or monuments were not disturbed or removed. State that the respondent's client did not retain the respondent to prepare a survey plat, and a plat was not requested. The complaint materials were forwarded to a contracted complaint reviewer for analysis to determine if probable cause exists for discipline. The findings of the complaint reviewer are as follows. This complaint concerns an ongoing dispute between neighbors. No violations are noted, as reviewer cannot confirm if the respondent removed any property markers as alleged, and the standards of practice do not require an issuance of a map. It probably should be a plat. The reviewer did note that the respondent should be aware of the standards of practice if the allegation of the testimony in court is true. There's no complaint history for this particular respondent. So the recommendation is to close the case with the letter of warning regarding our rule that applies to maps and mapping.
Okay. Any questions concerning this particular case?
I guess, Rob, my only question really would be that the letter of warning that's being recommended here, is that in response to where it says up here, if I understand it correctly, that the respondent testified in court that he did not know if a plat was required? So basically his lack of knowledge, that's the letter of warning. Okay.
Otherwise, we would probably dismiss it or close it. But we don't want our registrants saying that they don't know what the standards of practice are.
Uh,
Any other discussion concerning this particular case?
Yes, Mr. Chairman, let me look something up here just real briefly.
Okay.
Rob, if you would, real quick, just kind of go over the levels of letters that sometimes are issued, letters of caution, letters of warning. Am I right?
Lowest is a letter of instruction.
Thank you.
We give those to people that are brand new and probably didn't know any better. Caution is when we think you were sloppy, you should have known better, and you just didn't do it. Warning is when we think that you probably did something wrong and you've been around long enough that you shouldn't have done that. From there, it goes to formal discipline.
So after a letter of warning, it goes to a formal hearing? Is that right?
It goes to formal
Yeah.
discipline where we assess penalties and offer settlement offers, and it could go to litigation if they don't accept the offer. That's what a consent order does. This person's never had a history before.
If I read correctly from the reviewer, no violations are noted.
As far as preparation of the document.
There was no preparation, is that correct?
Well, there were some field notes and
Okay.
stuff.
No formal plat was created, as it wasn't requested, nor is it required. Is that correct?
Well, plat was not requested. They were just supposed to set out the boundary. So there was a drawing, but it was a product of him doing his work.
Let me review, Mr. Herndon, if I can, the statement that you made that the respondent stated in court that he didn't know if he had to do a plat or not. I don't want to put words in your mouth.
I think it was he didn't know if a plat was required to be issued or not, I think is accurate.
Well, I have an issue with that under our current existing rules of conduct, 0820-4-.04 public statements, paragraph number 1. He was testifying in a court as a witness, and he made a statement about his profession of something that he was not aware of. If he was going to testify in court, I think he should have done his proper due diligence to know whether he should have to do that or he should not have to have done that. I think that the fact that the reviewer was enthralled with the plat and whether a plat was done or if it was done or whatever, I don't think that's the thrust of the situation here. I think that the public statement issue is much greater than the situation about the plat.
Well, he didn't say anything that was untrue. He truthfully stated he didn't know.
Well, that's the way I took this particular case, was that was more the more egregious potential violation as opposed to not supplying a plat.
I mean, we can bundle
What his
that.
requirements were.
Right.
Yeah, that is the issue here. My understanding is that is the issue, the fact that he just did not know.
Okay, well, we can bundle that into the letter, the warning letter. Yeah.
I just feel like it has a whole lot more teeth if we put that in the letter as opposed to the fact that he didn't know he had to do a plat. You know, I just feel like that if an individual is of so mind, whether it be antagonism or whatever, to file a complaint, then I think it's incumbent on the case reviewer to review, what's there. In other words, we're not on a witch hunt. We're not trying to dig something up, but at the same token, we need to find out, what is the potential violations. And I think it's my opinion that this is a much more severe potential violation than what the case reviewer determined.
Anything else as far as the discussion on that? Recommendation then to Rob would be to include the section of our rules that state what the respondent should know.
That's the direction I'm going in, Mr. Chairman.
Yeah. I mean, that's just a recommendation from the board. Sue, any other questions or anything about that? Okay.
I'm good. I would concur with the recommendation.
Okay, well, I'll make a motion then, if it's all right with the chair, that Mr. Herndon draft a letter of warning to this particular respondent, citing what the complaint reviewer cited, along with 0820-4-.04 public statements section, and direct particular attention to that, to the respondent's attention.
Okay. Motion on the floor is to do as Mr. Lingerfeld has stated. And Rob, does that meet with what you think you can do with that?
I think what I understand is if you're aware that you're going to give testimony in court, you need to be prepared. A thorough and truthful statement and not say you don't know, because you're actually there to provide information to the court. That's why you're there, and you should be able to provide that information.
Needs to know what's required of him in the standards of
You
practice.
need to know that anyway, but you don't need to broadcast it to everybody that you don't know it.
No. Okay. So with the motion that is on the floor, do I hear a second?
Second.
Any further discussion? All right. All in favor?
Aye.
Opposed? All right.
Number 2, this is case 2014-018081. This complaint was filed by a consumer concerning a boundary dispute. The complaint alleges that the respondent, a licensed surveyor, produced a survey with numerous errors and inconsistencies and failed to recognize monuments in previous surveys. Respondent requests that this complaint be dismissed as it was the subject of a previous complaint, which was number 2012-02568, which was closed with no further action. Complainant denies allegations and states that the respondent served as an expert in a civil court case regarding the subject boundary dispute in which the court upheld the respondent's survey. The complaint materials were forwarded to a contracted complaint reviewer for analysis to determine if there's any probable cause, and the findings are as follows. The reviewer states that the respondent did a great job with due diligence, research, communication with the parties, and provided professional court testimony. However, the reviewer discovered that the certificate of class and accuracy of survey does not show the actual unadjusted ratio of precision, in violation of the rule for survey types and requirements. And then there's a paragraph. The respondent's complaint history is as follows. There's one in 2004 dismissed, 2006 dismissed, 2006 again dismissed, 2008 closed with a $500 consent order, 2009 closed with a letter of warning, 2012 closed with no further action. I think the recommendation should be close the case with prejudice with a letter of instruction regarding the appropriate rule here for survey types and requirements only. I'll go ahead and let you know this particular registrant, what he does is boundary dispute. That's what he does. So that's why there's so many complaints opened against him, because I've talked to him before and I don't know really why he would want to do that exclusively for a living, because that's just a bad divorce every time. But, you know, somebody's going to lose, somebody's going to win. So we dutifully, and it's fairly common for people to continuously send these complaints in after we've talked about it. So sometimes I have to ask you to close it with prejudice. So whenever they file another complaint, we don't have to, you know, they've had their 15 minutes of fame, you've talked about it. We spent your time and the state's treasurer to discuss it, and public policy is that these issues need to be finally adjudicated. So that's why I'm saying close with prejudice, because it's done and been done. If there was some minor discrepancy somewhere, fine, we can send a letter of instruction to show our displeasure and be done with it.
Was it verified that this complaint is directly related to the previous one that's already been dismissed, the 2012?
Oh, it is, yes, it's directly related to the 2012 one. Same everything as the 2012. I thought, for some reason, I was thinking you were talking about the previous case, but no, it's exactly the same. When people send this stuff in and they say, I've got new information. Okay, so we send it to the reviewer. But then, even if it is new information, it has to be substantial to the fact that you would not have ruled as you did. So due diligence, send it in, let him review it. This particular reviewer hates it when people don't put the actual adjusted ratio on there, and I think you've heard that before. It's a common thing that people do, but that was the only.
I think I've run across a couple of times that I don't think folks understood what that statement says, and particularly in planning commissions, but we'll get into that later. But the other discussion, and further discussion on this, any of you guys?
I really don't have anything to add to it. I'll go ahead and make the motion if you're ready. I'll go ahead and make the motion to follow staff's recommendation of closing the complaint with prejudice and include the letter of instruction.
Okay. Motion on the floor is to follow staff's instruction. Any further discussion? Do I hear a second?
Second.
Okay. Now any further discussion? I guess not. All in favor?
Aye.
All right.
Number 3 is 2014-021541. This complaint was filed by a fellow practitioner concerning the respondent's office location and potential violation of our rule that says you gotta have somebody at each office that's licensed. The complaint alleges that the respondent, a licensed surveyor, provides land surveying services at one location where the respondent is the only registered land surveyor employed at that location. The complainant states that the respondent opened a second location and attached a copy of a newspaper article and advertisement that lists each address. Respondent states that when the respondent entered a lease agreement for the new location, the respondent was unaware that there was a new rule requiring a registered land surveyor to be at each location on a full-time basis. I'm not sure that's a new rule. Respondent states that as soon as the rule was brought to the respondent's attention, the respondent pulled all possible advertisements, but some had already been printed. The respondent states that the advertisements were reran with only one address, and further states that the second location was never a functional office. Clients have never met at that location. It's only being used for storage until the lease expires. There's no complaint history for the respondent. The recommendation is to close the case due to insufficient evidence to establish probable cause for discipline based on the newspaper article, and the reason I've made that recommendation is because we don't know he ever actually occupied that office or tried to do any business out of it, or actually violated the rule in a physical sense. So,
I don't know. I don't mean to jump in front of you there.
well, I'm trying to, I try to think ahead, as I do for every case. What would happen if this went to a formal hearing? Would there be enough proof
Sure.
to prove it? And our evidence would be a newspaper article.
Well,
But-
the one key word that really stands out to me under 0824-09 is offering to provide land surveying to the public. And just without, obviously I haven't seen the advertisement, but an advertisement that obviously it was for his business, and from the information I have here, lists 2 separate independent addresses for his business. Isn't the purpose of an advertisement to offer the services?
Oh, I could see his potential defense being, well, I was going to hire another surveyor to be in that office.
It doesn't say, but it doesn't say with the potential of, it says that you cannot, with the purpose of providing or offering to provide. I have real trouble accepting the recommendation just on the face of it here,
Okay.
of closing the complaint. I think this bothers me, to be quite honest with you. I mean, this is right in the face of exactly what the rule says you cannot do. And if the respondent claimed that it was a new rule, I don't know what his definition of new is, because if I read it correctly here, it was established in 91, 92. We're looking 20 years. That's not new to me. I have a real issue with letting this one go without at least a letter of warning of some sort.
The thing that seems to be developing just from this legal report is that there seems to be a lot of our registrants that don't know what the law and rules are. I don't know what we can do.
Their responsibility being a profession of knowing the rules.
And I don't really know
So
what we
that
can do
doesn't
about
slide
that.
with me.
Well, I mean, I'm not offering it as an excuse. I'm offering
Right.
it as a problem.
Yeah, no, I understand.
I just
But,
don't know what we can do.
I just read into this as he went through the motions of acquiring or leasing space with the intention of offering the services, thus the advertisement. Again, just reading into it, looks like somebody brought it to his attention, he got caught.
The whole thing comes down to where he didn't know the law. Didn't know the law or the rules, just like the other guy.
I just can't accept closing this complaint without some sort of action here. I think there has to be of some sort of repercussion to his actions. Not knowing the rules is no excuse. The fact that he advertised it really puts it over the threshold for me. I mean, that was an offer of services if it's advertised at a second location on the same ad. I don't know, I want to hear your thoughts. Tim, Galen, Sue?
Well, first off, I agree with Mr. Kaufman, and that was the exact direction that I wanted to go with it. So my question to you, Rob, is if this board feels that there's any civil penalty involved, which violation category would it fall under?
It would be under 101, offering
Under 101?
services,
Okay. Okay.
if that's what you want to base it on.
Well, as Jay has eloquently said, I'm just as passionate about these rules as he is, and I am very non-tolerant of a registrant telling me that they don't know the rules or misrepresenting the rules or any form thereof. And the only way that I think that we do our job properly is to do something in this instance. And, you know, I feel like that we would be totally remiss as a board and as a fellow professional to not have some type of penalty on this. And my feeling is the maximum that's allowed by that particular section, that's why I asked, is $1,000, and I feel like that's what the penalty should be.
He's in the 2000s, so where would that put him?
That doesn't, how much?
Probably about 10 years at least.
See, that doesn't mean anything anymore with the number system that you all use, the licensed folks, that does not mean anything whatsoever as far as when you were licensed. It used to mean something, but it doesn't anymore.
You have to look it up on RBS, I guess. I don't know if you can do that.
Funny, you could since the internet's up, you can do a license search over here real quick.
I'll be honest with you, it doesn't make a difference to me. It's
No, it really doesn't.
Or
I
just
agree,
as a
but I mean,
year or
just
20.
as an answer to Sue's question.
The gentleman, obviously the respondent, is a licensed surveyor, so he needs to know what's in the
That's correct.
book.
no question.
I kind of,
You know, Rob, I liken this situation to a complaint we had a 3 years ago about a gentleman that advertised on his business card that he was a licensed surveyor in the state of Tennessee.
No difference.
It's
had
the
a
same
hearing
thing,
about that.
you know.
Is that the one we had the hearing on?
Yes.
Had a business card. He had no license at all, and he was offering services. He has a license, but an unlicensed person is not bound by our laws and rules. A licensed person is.
Well, the one I'm speaking of in particular, the gentleman had been licensed, let his license lapse, and was continuing to advertise.
Let it go.
I think his comment was he meant to get relicensed. Well,
This counts in, what is it, horseshoes and hand grenades?
Yes.
That's the only time close matters.
All right. Well, all right, any further discussion?
I really don't. I do like Tim's suggestion there that we, if I understand it correctly, I don't mean to put words in your mouth, that we move forward with a civil penalty.
yes, sir.
Okay.
So I'd like to put that in the form of a motion.
All right. Need to state your motion, how we,
I'd like this board to move forward with the issuance of or the actions to move towards a civil penalty under TCA 62-18101B with a maximum penalty of $1,000.
okay. Motion being stated, I hear a second.
Second.
Any other discussion? All in favor?
Aye.
And opposed? Okay. All right.
They like to volunteer to write an article for our newsletter about how important this is, to know the law and rules. Doesn't even have to be a long one, just please know the law and rules or something bad will happen to you.
They know when they're updated.
Not any one of us would be afraid to write that one.
Well, they can,
Surveyor know that they're updated unless they go on the internet every day.
It's their
rules
responsibility.
are updated. When we get new rules, like when our new rules finally get passed, I'll send them copies of the new ones. So, and then they can get a copy of the law book. All they had to do is call me, or they can go on the internet and get it, or to them, I can email it to them, however they want it. Except I don't take it to them.
Huh?
Except I don't personally take it to them.
And delivered,
Looks
right?
like we
Right.
need to.
Okay. The next one, Mr. Rob.
Last one, 2014-023-131. This complaint was filed by the board concerning information received that the respondent had been disciplined by another state's regulatory board, stating certain plats were not in compliance with the board's standards of practice for surveying for that state. The respondent states that the violations were due to a drafting oversight, stating in detail the reference line or bearing of basis line was incorrectly shown. The two western corners of the tract were monumented twice but not shown as set on the plat. The commencing point was not labeled or described on the plat. And the vertical datum was listed within the benchmarks but not annotated by itself. The respondent fully accepted the responsibility for these errors and agreed with the consent order, which provided for a civil penalty of $250 and the requirement that the plat be updated and the production of 3 additional plats. I don't know why they asked them to do that. So this is basically a reciprocal action. Didn't do anything here. But with NCAAS that we belong to, reciprocal action is allowed. We don't really do it much here, but it happens, and it's happened here. So normally, if it's less than revocation or suspension, the way they do it in some boards is that they administratively issue a letter of caution. If it rises to the effect of they've been revoked or suspended somewhere else, then it comes to us, legal. So just in sort of mirror that, I've recommended a letter of caution stating that any professional services in this state must comply with our board's standards of practice.
Yeah, I have no problem with that whatsoever. It seems that the respondent fully accepted responsibility for the errors, owned up to them, tried to make right with the state that he originates from, and this is just a response from the state of Tennessee, which he happens to be licensed in as well. So I'm good with the letter of caution. I think it's a great idea.
Just as a point of clarity, Rob, I think the submission of 3 additional plats was to determine if the registrant was being in conformance. I don't think it's 3 additional plats of this particular issue.
Okay.
I think he cleaned this one up, and then they wanted to see some additional plats. I know several states will have a respondent submit plats. I know I've seen as much as up to 6 months or a year, so that the board can actually review to make sure that respondent is doing what the board has asked. And that's what that is, I believe.
Well, thank you for that, because I didn't know. I appreciate that. They just want to see work product to assure themselves that you know what you're doing.
Yes.
Okay. That's it for the legal report. I'll go ahead and,
Well, we need a motion then
yes,
on this particular complaint. So I'll entertain the motion.
I'll go ahead and make that motion following the recommendation of staff, including the letter of caution.
Okay. Motion's been made. I hear a second.
I'll second it.
Okay, second. Any further discussion? All in favor?
Aye.
Opposed? Okay.
before
Rob?
we get out of the legal report, I just wanted to tell the board that our continuing education standards of practice rules are on their way for signature by the Attorney General and will become effective early next year, I guess. So
Wow.
in the interim, though, I want to again remind you that the the Government Operations Committee will probably want us to go up and explain these rules, so keep that in mind. When I get the letter saying you're scheduled to come, some of y'all I'd like to come with, so you'll be available to explain what the rules are so they can approve the rules.
That both set of rules we're working on, conduct and continuing education?
Right, they're gonna go at the same time.
Okay.
And we've got a project we're working on today that I'm gonna get set for a hearing. That'll be later, as we discussed about the agenda.
How long will this meeting be? How long do you think that'll take to go through these particular things? Will they want to go through them with a fine-tooth comb, or will they already have taken a look at them and just pick certain things that they want to ask about?
Well, just from my experience, when you go up there, there's a laundry list of all these other departments that have rules. And hopefully you're at the top of the agenda. If you're lower down, they may not get to you. But since we're not changing fees or doing anything with money, they probably won't ask that many questions. Probably just, why do you think this is necessary? What's the reason for this? And you know that, so no problem. If you did something to your fees or something, they would have a lot of questions about that. We're regulating our profession. We're updating our standards of practice, our continuing education. This is what we need to do. It's pretty clean about why we're doing this. So
Okay.
I don't expect any problems at all.
About when do you think this might be?
Well, if I send them up, if they got signed today, it'll probably get signed next week. When I get the signed copies back, I'll file them with the Secretary of State. It'll be 90 days. So November, December, January, mid-February, probably before our next meeting,
Okay.
will be effective.
The meeting before February, then, before they take effect.
Our February meeting's at the end of the month?
No, we don't have a meeting in February, it's the end of January.
Oh, it'll be after our next meeting then, maybe. We have a new Attorney General, I think you probably know that. That may slow it down a little bit, I don't think it will, but it'll probably be February.
Okay. Well, proceed on with whatever it was else that you had. Anything else?
No, I was just giving you an update on that. Where did y'all put the discussion on the next rulemaking project, after director's report?
Yes, sir.
Okay, so that's where we are.
Well, we're ready for the director's.
First, on the director's report, we need to discuss changing the January 2015 board meeting from January 29-30 to January 22 and 2030. Is that right, Tim?
Yes. I have a EPS committee meeting on the 29th, 30th, and 31st in Clemson. And I would like to attend the board meeting if at all possible.
Date you gave me again were what?
22nd and 23rd of January. 22nd and 23rd.
22nd,
Uh-huh.
23rd, okay.
It's the week prior.
Yeah. Okay. Well, that's written right there. Okay. Next.
Oh, that's right.
We need a motion on that.
Yeah.
Okay, I'm sorry. Then I'll entertain a motion to change the dates of our January meeting from the 29th and 30th to the 22nd and 23rd.
So moved.
And a second?
I'll second it.
All right. Any other discussion? All in favor? Okay.
Now we need to talk about the qualifications for licensure. Once these people have passed their fundamentals exam, Galen, we talked about that. Remember? You're the one that wanted me to put this on here.
Yes. The qualifications for licensure have been passed, and there was, I know that there has been a request to be able to set for the PS and what have you without having experience, the 2 years experience that we are requiring right here. So,
Well,
but
Well, that's actually something I think, Mr. Chairman, that I'll speak to about in the EPS committee.
Right.
But I think Donna has a little different situation here, I believe.
Okay.
No, that's not the same one. This person passed his fundamentals exam prior to the 2016 or 17 date, I can't remember which. But the rules say if they have a college degree, they have to wait 2 years from the date of passing the fundamentals. With a high school diploma, they don't have to wait that 2 years if they pass it. I think it's what he's,
10 years,
well, he's got all of his experience.
yeah. But it's 10 years
10 years
after
after.
passing. Now, the passing date is, the date that the individual passed the FS is the critical high water
All
mark.
right, so we passed last week.
Huh?
Let's see. He just passed it. So,
When you say just passed it, what was the date he passed it, Donna?
second,
Of October? Okay. So he now needs 10 years of experience.
all right. That's not the way I understood it, but that's fine.
Under the law that we're now functioning under for licensure, which came about in June of this year, it stipulates that the path to licensure for a high school applicant, if I recall correctly, I don't have it in front of me, is once they qualify for the FS examination, which, let me back up a little bit. They had to have 10 years of experience to qualify for the
test.
FS examination.
And now
Then-
he wants to.
Then after the FS examination, let me get that law. I don't want to misstate that.
That's where I am fuzzy. Here it is, right here.
Got it, thank you.
Right there.
Oops. Okay. And take the PS, yes.
Yes.
Because he's in that sunset window.
Right, he
He's
passed
in
the
that, yeah, that's
fundamentals
correct,
before.
that's correct, yeah.
Yeah.
He's in that window. Yeah, I initially said that incorrect, but he is in that window. So he will be able to take the PS upon making application and approval by this board.
Yeah, when does that window change? 2016? 17.
17.
Now, to
That's what I
be clear, if they.
That has not changed.
That's not changed, that's where we go with that. But if it's
Yes.
high school, it's.
High school's different. The high school and the associate degree have a sunset.
Okay.
And we have to be careful how we fall into that sunset. And I stated the 10 years, but I stated it incorrectly,
I know
what it
what
was tied to.
Yeah, I know what you're talking about.
That's why I wanted to see that, thank
Yeah.
you. But yes, that person is in a sunset, and they would need to make application to take the PSTS.
Right.
And then this board would have to approve it, and then they would fall into a regular scheduled examination routine.
Right, okay. Okay, next on the list is to discuss the photogrammetrist, or at the least, a method to regulate UAS. Discuss licensing a photogrammetrist.
Chairman, could we withhold that until the TAPS committee report comes up, since that's basically tied to that?
As far as I'm concerned, anybody else have any problem with delaying that, and we'll discuss that when the TAPS report comes up? All right, let's just delay that particular one, we'll come back to it, okay?
Next one is to review the continuing education from individuals. Y'all should have packets on that. Right behind the director's report.
That was the gentleman from West Virginia, is that correct?
Yes, starting with that, yes. Y'all reviewed this last time, but you wanted to submit some more information, so he did that. You know, a syllabus and all that stuff.
I recall, Donna, we approved these 3 courses subject to receiving
Right.
this. So we just need to actually formalize our approval, basically.
Right.
Yeah, from our prior meeting, based on the minutes here, I had made a motion to approve his education contingent on the fact that his education from South Carolina was the same as approved for Tennessee. It was seconded by Ms. Braley. Motion carried unanimously. Rick Bowers requested that his continuing education be reviewed. Motion to approve 12 hours of his education, and that he turn in the course reporting form with the course completion certificates for the rest,
Right, and he did all that, so.
which is what we've got here. Okay.
And he sent.
Motion was carried
you know,
unanimously. Yeah, okay. So what we're looking for here is course completion certificates.
Right, and he's got a
He's got those.
syllabus of the,
Okay.
or a pamphlet or whatever it is.
Okay.
In case you need that, so. I mean, he's complied with our request, so.
Nothing else that we need on that then?
I don't believe so, not on Mr. Bowers. I think he's good.
We need to just make a formal motion to approve, that actually formalizes or finalizes his PDH hours that we approved.
I'll accept a motion to that effect.
I'll make a motion that we approve the 12 hours that we had previously tentatively approved until we saw this documentation. And we now have the documentation unless we have any, I didn't have any issue with it. I think we should go ahead and approve the 12 hours that he's requested.
Okay, motion is made. Is here a second?
I'll second that.
Any other discussion? All in favor?
Aye.
Opposed? All right.
Okay, this next one, he's been approved for the hours. He reapplied, because his course is expired and he reapplied. They were approved for less hours than originally approved. And he's unhappy with that, and he wants y'all to review it again.
This Mr. Thompson? Okay.
He's got letters in there, he's got a petition in there, he's got he can't understand why, they were approved for less hours this time than they were originally.
Well, among other things, I noticed that when he spoke to each individual course, there's a question on there. It says, has this course/seminar been accepted by other state boards of examiners for land surveyors? And he says yes. And he did not indicate any proof of that whatsoever anywhere. That anybody else had accepted his seminars and approved. The point here is that he doesn't agree with the hours that we have allowed, via recommendation from our advisory committee, which we fortunately have a member here with us today that could speak to that if necessary, that we didn't give him the proper hours. Well, if his courses were approved by other states and he had documentation as to what they approved, then certainly I think this board would consider that. But in my review of what he has sent, the most paramount comment that I feel like is that I think that this board should require this gentleman to attend an ethics seminar on professional writing and speaking, because part of who we are and what we do is how we represent ourselves, and the way he has represented himself to this board in this issue, I myself am appalled, and am not pleased to know that this individual speaks that way as a registrant of our state. Now that's my soapbox, but I really have an issue with what I see going on here.
Yeah, I'm going to expand a little bit on what Tim was saying right there. He certainly is I would put this politely, assertive in his actions here, and the grammar and spelling in his correspondence needs a little bit of help. But other than that, there is one point I do want to make here, and I want to make sure I understand this correctly. In a letter that he dated on 7/19 of 2014, it states here that previously in February he had voiced his dissatisfaction and asked the board why the reduced hours. And then also says, in his letter, he states, the board replied after the April 10th meeting that the board voted to leave the hours as they were. So we've already addressed this once before. I don't know what the message would be if we were to change those hours at this meeting right here. Personally, I think that would be in a bad showing of the board's stance. So I do understand his situation. Obviously, he's expressed his dissatisfaction very clearly and quite assertively. But personally, it's my choice here to leave the hours as we've previously approved.
Well, I think, just as an opinion, I have to agree from that standpoint. As the chair, I'm like the rest of you. We are in a profession, and we have been presented information that we've already acted on. So, like if you go to court with the same thing, you don't have any extra evidence or what have you, they're going to say no new evidence, and they kick it back out. So we're not a court of law, but we are a board of examiners. So any further
I
discussion?
guess, Rob, I might have a question to you. It feels appropriate to me that this board take no action whatsoever, because we have already acted as Jay said.
Yep.
So
Yeah.
it's my opinion that I would say to the chair that we just move on to the next item.
Already decided.
Right.
Just like we said before in the complaint report, people keep sending the same thing, and public policy demands that we bring these things to a resolution and move on to new business. Because we can't invest your time in the same issue over and over.
There's no need
Eventually, you're
for
gonna
a
have to say
motion
no.
then for this. Let's just move on to the next one. We've already,
Next one
next one.
is, I'm pretty sure it's gonna be okay, but before I gave him credit, I want y'all to look it over. It is Ryan Beasley, Opus Projects from the National Geodetic Survey. Is included as syllabus, along with his certificate of attendance.
I'd be glad to speak on that one, as I had the fortunate opportunity to attend the same class, but at a different opportunity. I'm assuming that the agenda and the material covered and the experience was similar, if not identical. It's just a different location is all it is. It is sponsored and conducted by the NGS. Outstanding training. I have zero hesitancy in approving those hours right there at all.
I figured they'd be okay, but I just wanted y'all to take a look at them.
Okay. Any other comments or discussion? Motion to.
I'd I'd set the motion to approve those hours as requested.
Hours.
Yep.
Second?
I'll second it.
Okay. Any further discussion? All in favor?
Aye.
Okay.
Okay, and that.
Please.
2 days.
yes.
Wow.
My next thing is, we have hired a new person in our office, and he's gonna be working on the newsletters. So we need to get articles on from y'all, or TAPs or anybody, newsletters to put in news articles to put in the newsletter. So that one you said you would do about the earlier, that's a good one.
We have a date that he needs that by?
I don't know, I'll check with him at lunch and see.
Yeah,
I
please
thought
let me
about
know.
that after I got down here.
Good.
But I'll ask him. And then I got that one from you the other
Right.
day.
It would be real nice if we kind of had a routine target date.
Yeah.
So that we'd sort of have a consistent publication date for
Right.
each of the, basically, we're only doing 2 newsletters right now a year.
Yeah.
So if we could kind of set up some target dates, and maybe that gentleman may help you with that.
Yeah, and he is, in his degree in school of journalism, so he's, he likes to do that kind of thing, writing and stuff like that, so he ought to be pretty good. Okay. And the next thing is to sign the wall certificates from the April exam. And there's some information down here that y'all can read about the budget and the FS exam information and licensees and all that stuff. And that's it for my report. Galen, do you want to take a break and sign these things?
Yes.
Okay.
If you don't mind, time now is 10 o'clock. Break time.
Do y'all have a black pen?
All right, break's over, 10:23, ready to
They
be
don't know what's in
resume
it, but they
business.
carry it.
And the next thing we have is, are we continuing with whatever, did we get done with what you need to get done with, Donna? I guess we're on the next item on the agenda.
Yeah.
Whatever the next item on the agenda is here.
That's what stuff Robert had.
Okay, yeah. Rob and the rulemaking,
I
so.
passed out these two documents to y'all, and I think everybody's got them. So what I've done is I went back through the notes that we talked about last time and incorporated them into this that you have before you. So all we need to do is look through it one more time, and if y'all adopt this draft, then I will send it on its way to get its approval so we can get a hearing set. After that, we're gonna look at this Reg Flex document and answer the questions and vote on that. And then this project will be on its way. And like I said, the last two chapters are on their way to get signed and become effective. If we can get this one done pretty quickly, then all of our chapters will be done.
Yes, a question, Mr. Hernan. We've talked several times about QBS and the potential of putting QBS in this chapter.
I actually talked to a lobbyist that was at our retreat for the engineering board about actually getting that law probably revised. That'll probably happen this session. It won't be anything that we do at the department. Somebody else will propose that law. And whatever comes out the other end, I think we need to talk about that. And then, but wait and see what it looks like after legislation happens, and then we can, because there's a couple of things we still need to do. I think you and I talked about the incompetence thing, changing the language for that, and then we can do the QBS thing at that time, if that's satisfactory.
Good response. I see some hope in that.
Yep. The QBS thing is a bit confusing for everybody, and it needs to be clearer than it is. Try to do. And I'll probably work with him to get the language to where everybody can understand it, because if we as regulators can't understand it, how do we expect other people to understand it?
Changing hat for you for a moment, then, the engineers basically gonna hold pat where they're at and see what evolves from the legislation as well.
That'll affect them too. It'll affect you and them and the other contractors that we don't really worry about, but some other professions that are bound by qualification-based selection. So we're just waiting and see. Here, I think if I go back to my notes, we took out meetings because we're not doing anything to rule number 1. And on rule number 2, applications, we had an application for registration should be accompanied by 2 survey plats, and then we had each with the written survey report, and y'all talked about that, and came up with we need to change survey report to narrative summarizing procedures and conclusions relative to the plat's development.
Typo there in development.
Because it's underlined, you know, it puts a little red line if you misspell something, and the underline covered it up. Thank you. Otherwise, I would have embarrassed myself like that. So that's what I took away from your discussion last time. Is that pretty accurate? Next thing I changed. On the second page, syllabus of examinations. The last sentence used to say the examination will include the following subjects, and now we've put but not be limited to. This will keep us from having to revise our rule constantly as the exam changes. Now, the next thing we changed is rule number 5 under fees, where we've sort of recalibrated the titles and everything there. I added professional land surveyor over application fee, because that wasn't in there. Out all of the civil penalty stuff, because we're not doing anything to that. And the last thing was adding this new rule for military spouses, which the General Assembly is requiring us to put in. Pretty much a duplicate of what the other boards are doing, more or less, sort of a template. Put it in, but whether or not we ever use it is another matter.
Would you anticipate trying to do a rulemaking hearing on the 22nd of January at our next meeting for this?
Well, on the next document here, this reg flex on the second page, description of proposed rule, I had proposed rulemaking on January 29th. I made a note to myself to back it up to the 22nd. That means that I've got to file the notice by November 26th for us to hit that date. After you approve it, I've got to send it to the department for its approvals and all that. So I'm really, really hoping to hit the 26th to get it 5 days plus 5 work days for 50 days.
Okay, with this, then we need a motion for the notice of rulemaking hearing on these things that you have edited and the changes we're going to make.
Based on your discussion.
Okay. Any discussion further that we need to take on the very first thing that we've gone over here with the changes that we had? Lou, Jay? Other than the one type.
A discussion here under the syllabus of examinations where we added but not be limited to.
Yes.
The entire sentence says the examination will include but not be limited to the following subjects. If I read that right, that's mandating that the exam will include those 4 items, A, B, C, and D.
We can change will to may include.
That's where I was going.
Okay.
That's where I was going.
All of that.
Idea on that one anyway.
Just as a question, Rob, under the military spouses, yeah, I'm fine with what it says, but it's just kind of, I'm not sure what the purpose of the wording of item number 2 is. If the person provides satisfactory evidence of the requirements above, except item A. What does that have to do with it? How does it become a requirement even listed if it's accepted already?
Permit. That would give them time to come up to all the standards. And you'd require them to take an exam or something. Here's your temporary permit. You got to take and pass the exam. Yeah, paragraph 1 says, we give them a license to reciprocity if they meet A, B, C, D. You're talking about temporary permits.
Right.
I think it helps our cause.
Bob, on page 4, 0820-01-04 syllabus of examinations, 1D, the next to last sentence, it says surveys and aerial surveys with photogrammetric methods of compiling aerial photographs. It's my suggestion that the elimination of compiling aerial photographs, that should be eliminated. That does not read right, in my mind.
Paragraph D,
Yes, sir.
surveying of areas for the conveyancing of land, for the establishment of applicant should be able to divide areas into smaller tracts. Layout and plot. Prepare topographic maps using ground surveys and aerial surveys with photogrammetric.
That should be where the colon comes in right there.
Yeah, it could.
And then of compiling aerial photographs, you're talking about two different animals there.
Yeah, it doesn't mean
Be
what the intention is.
semicolon, strike of,
Like of,
compiling aerial photographs
Right.
is its own issue, okay.
yeah. If you strike that, then that reads correctly. Right now, it's confusing. It doesn't say what it's supposed to say.
Right, compiling aerial photographs is its own thing.
Okay, any other discussion we have on this? If not, I'll entertain a motion to allow Rob to proceed with the presentation of our corrections and additions and deletions as he has suggested to us.
I'll make that motion with the correction, additions, and deletions as noted.
All right, a second?
I'll second it.
All right, any further discussion? All in favor?
Aye.
Opposed? All right,
Our final thing is this document memorandum. Regulatory Flexibility Act, TCA 4-5-401 et sec, requires us to do this. And the first two paragraphs are why we have to do it, so let's just go to page 2. Description of proposed rules. And this is just a synopsis of what we're doing. The proposed rules have been approved by the board. Rulemaking hearing is proposed to be held, change that to January 22nd, 2015. Notice must be filed with the Secretary of State no later than November 26th. Bullet points summarize what we're going to do to these rules. November 26th will have to be our drop dead
Okay.
filing date to hit that January 22nd. Are okay with the bullet points, we'll answer these questions. Now when y'all are ready to talk about the
Those are just standard questions? Those are the questions everybody answers? Yeah, okay. Well, it seems pretty cut and dry
Same
then.
every time.
Yep.
derived from the statute. Ready, we'll answer them. I've already put some suggested answers in here, but you're not married to them. Ready, I'll read them into the record, the questions.
Discussion before he does. Okay.
Question 1 is overlap, duplicate, or conflict with other federal, state, or local governmental rules. The suggested answers will be no overlap, duplication, or conflict with federal, state, or local governmental rules because our board is the sole authority for establishing minimum requirements for obtaining and maintaining a license for the profession it regulates. All of them, and you can vote on them.
Sure.
If you change any, we'll do it, and then vote as a block. Clarity, conciseness, and lack of ambiguity in the rules. The rules are clear in purpose and intended application, not subject to varying interpretations. Flexible compliance and/or reporting requirements for small businesses. The proposed new rule and amendments to current rules are not expected to impact small businesses. Know that until later anyway, after it's implemented. Friendly schedules or deadlines for compliance and/or reporting requirements. There's no variation in reporting requirements for surveying firms in Tennessee of any size. All businesses here. Consolidation or simplification of compliance or reporting requirements. These amendments and new rules not address the operation of surveying firms, only individual registrants. Performance standards for small businesses. These proposed rules have no effect on current standards. Barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. The amended and new rules proposed do not contemplate an impediment to innovation or increase in cost for providing land surveying services. Questions? Do you want to change the answers? And if so, how do you want to change them?
I'm good with it. Okay. Any discussion? All right. I entertain a motion to accept the. Second. All right. Any further discussion? If not, all in favor?
Aye.
Opposed?
Last thing, there's some additional questions added by the governor's office. Will make it better to do business in Tennessee. The suggested answer is yes. These rules propose to add methods of expedited licensure for military personnel and their spouses who come to Tennessee through the course and scope of their service. Does the rule make it easier to create jobs in Tennessee? Other than the expedited application process provided for military personnel and their spouses, these proposed rules are not expected to have a significant impact on job creation. Is it essential and effective? Yes. Who does it affect? The new rules will affect all registered licensees of the board and military applicants and their spouses if licensed in another jurisdiction. Rule positive move. Well, yes. Is it outcome-based? These proposed rules are expected to have a positive outcome in the insurance that only the most qualified land surveying professionals are awarded a license to practice by the board.
Discussion on those? Anybody want to make any changes, amendments, or anything? If those questions to the government, from the governor as presented.
I'll make a motion that we accept the answers as proposed.
Okay, do I hear a second?
Second.
Any other discussion? If not, all in favor?
Aye.
Opposed? Okay.
Right, we're off with these new rules. That's it for me.
Does that say it's quitting time right now for you?
Not quite, but
Not
I don't
quite.
have any, you don't have to listen to me anymore for.
Oh, okay. Okay. Next on the agenda, and it's Tim and EPS meeting.
Okay. I've given each of you a little handout that's stapled together. I'm not going to go through every little item on it. Going to speak to just a couple of things that transpired. I was at a meeting last Friday and Saturday in Rapid City, South Dakota for EPS, and the primary topic of the meeting, as always, is examinations for surveyors. And a couple of items that I think is important to our board to stay on top of is, number one, the FS exam now, they have what they call 3 windows behind them. And those windows have been very successful as far as administration. The numbers are down, and you'll see that in some of those charts that I've supplied for you also. And if you have, after you look at those, if you've got questions, I'll be glad to speak to those. The charts themselves, basically, one chart represents the FS examination results. And what they do, what NCAAS does, is they analyze who the takers are. Now, these are total takers, and the total takers are people that are first-time and repeat takers. So, and what they try to do is they try to ask them what their educational background is. So they can kind of track, you know, how does the exam do with this type of candidate? On that first yellow sheet, you'll see there that you'll notice that each of the dates under administration, that's the year and the month coming down the page. And now that we're at CBT, they have a new connotation. They've changed these. You'll see a C, and it says 01.06, which that means from January through June. So that's basically the first 2 windows. So you can see that if you look at an April exam in 13, there were 691 takers, and through June, the first 2 windows, which would be the same scenario, there's 367. So the numbers are way off there. So they're a little concerned about that. And it shows the percentages and relationships between those. On the next page, you have the PS exam. It's set up the same way, year, month. That's the pink page. And the last connotation you'll see has a P, because that means it's a paper exam. So they went to C and P for their. So the paper exam of April of 14, there were 495 people that took it total versus 13 of 598. The numbers are still down, and they're researching those, trying to figure out kind of what's going on there. So that's just a, sort of a quick and dirty. You can look at the rest of the chart and analyze it in your own mannerisms at your own leisure if you so see fit. But one thing they're looking at on the FS is, because of their experience with the current arrangement, is they're looking at allowing the FS to be taken every month of the year, anytime. Anytime there's a testing center open, take it. So they don't have these off windows. So I don't know if that could potentially become problematic for us in the method that we use to approve, but it may not, because we're basically approving already FS applications every time we meet. So we may want to stay with that, or we're just going to have to kind of see how that goes. But they anticipate making that decision about the FS sometime early next year.
Might be at the zone meeting, after the zone meeting that we'll meet with the Western group.
It will probably be discussed if it's not already in place.
Oh, okay.
It could potentially be in place, and as a matter of fact, you may hear about it when you go to the President's Assembly. So, the second item is they have already had Pearson View, which administers the FS. They've already had them review the PS, the questions, the whole format scenario, which, having went through it with FS, we pretty well had the PS stuff ready to go. So they're looking at on the potential for the PS to probably go back to about 85 scored questions with about 15 pretest questions. They're discussing time frames and things of this nature. So we've got a lot of things going on the PS that have not, final decisions have not been made, but it's still targeted for the last quarter of 16. So it's virtually around the corner when you talk about time and testing. It's not very long. The good thing about the PS was, different from the FS, was with the PS, we had already went to closed book and closed book reference. And by having closed book reference, that makes it much more easier to make that test CBT. Because you already got everything that you need, unless there's something that needs to be added to that reference book. But they had the questions in place, and they have the reference in place, so that makes it much simpler. One thing that we're going to see in the future, and this may actually help us somewhat with our state exam if we end up going that way, and I'll talk about that in a minute, is we're going to begin to do what they call innovative items. In other words, being able to do graphical questions on the examination.
Okay.
Maybe survey or a mathematical problem or something of that nature, that it could be presented on the computer screen, and then the examinee would have to respond to basically what they're looking at on the screen. So that's an interesting thing, and we're going to begin to explore those at the January meeting in Clemson when we review. So the exam is already successful to a point, and it's already gravitating to change, mainly just because of the way things are. But it'll be a much better exam, I think, when we get to the innovative items. I really do. It's strong now, but I think it's going to get better. Probably the single most discussed topic at this meeting was what they call decoupling of experience with examination. NCAAS, they have what they call a three-legged stool. They have education, experience, and examination. And what NCAAS has done on the engineering side is they have now decoupled the experience from the examination. So an engineer can now take the FE and the PE and then get their experience. Now, what that means is they don't get their PE license from their jurisdictional board until they've proven their experience with the board. But they already have the examination in place. The thought behind that is, if while you're in exam mode, you're going to be more successful passing the examination in that exam mode than you would be with lapses in periods of time. However, I think that they have asked my committee to look at decoupling experience from the PS exam, which effectively would mean somebody would pass the FS, pass the PS, and then get experience, come back, reapply, and then take the TS in the method that we use. I think the general consensus in the room for the surveyors was that it not be discoupled or decoupled. In other words, that it stay kind of as is. I would hope that that at some point in time that our board might be able to create a response. I personally spoke against it, not representing the board, but I personally spoke against it as a committee member. Most of the folks in the room spoke against it. It's not a dead issue by any means yet, but because we have a subcommittee that's reviewing all that and trying to come up with the pluses and so that's kind of the hot rock at the moment as we speak with our committee.
Reference to experience, Tim, coupled or decoupled, I guess a lot of applicants have a lot of experience a lot of times, and we are after they have taken an exam, whereas there are some applicants that have many years of experience. Probably are more beneficial to them than anything else that they may have done, but we are asking, I think, thought been given to considering experience prior to an exam. Suppose, for instance, the guy has 12, 15, 20 years experience, and then he's decided, all right, I want. Then what do you do?
Right. Well, that topic was only broached briefly from the standpoint that the greater focus was on the applicant that followed the path.
Okay.
So let's say it was a degreed applicant or whatever. Part of the problem with the scenario that you refer to is that we have such a diversity among the jurisdictional boards as how they get to the end result of licensure. That's part of the problem. From an NCAAS standpoint, the issue gravitates around the fact that the PS examination is practice oriented. Different than the FS, where the FS is the degree oriented exam for theory and so. Yes, is practice oriented. So the thought there is that, you know, if the exam maintains its status of practice oriented, yes, you're always going to have somebody that can pass it, you know, right after the FS, because, you know, there's always smart people. But at the same time, the thought was that then you get people, and Dole Allen from Virginia mentioned this very thing, you get people that say, well, that's fine, I'll just go ahead and start taking it. And while I get my experience over the next 2 or 3 years, I'll be able to pass it when I really do get my experience. But in the meantime, I'm going to take it 5 or 6 times.
Yeah.
You know, if I get lucky along the way, that's just a few times I don't have to take it. So that was mentioned, that you're going to get people that's just going to start doing that, which at the end of the day, that in my mind, and I know this is what Dole said, it devaluates the examination. You know, because basically, in any exam scenario, you only have so many questions. Mm-hmm. You know, for example, for an exam, for a CBT exam, if it's got 100 questions on it, you've only got an item bank of about 600 questions. So, you know, over several exam sittings, you're starting to pretty well cover that.
That's right. Because
the way CBT is in particular, they kind of make sure you don't take the same question twice. So that's pretty sophisticated. So, you know, if you start taking the test multiple times, then it becomes problematic for the test and the people administering the test.
Yeah.
So, you know, that's kind of a situation too. Your point's well taken, and like I say, it was broached, but it was not discussed in length.
Well, I think there again, each jurisdiction has its own requirements, and those boards could review an individual applicant and say, hey, you've got the experience, all right. yea or nay to allowing that individual to go ahead and take that
Now,
exam.
the last piece of paper in this little packet I gave you, you can read, I won't elaborate on it, other than that was a presentation that I made to the EPS committee relative to survey and licensure. And my scenario there was, to strengthen the PS exam to where we became basically a two-exam entity like the engineers are. And what I say there basically is that if you think about our examination process, you do the degree, that's what we give. Ultimately, now you're asking somebody that's passed those first two exams to really deal with what I'm gonna call jurisdictional issues. In other words, our laws and our rules and things that are specific to the state of Tennessee. Well, the difference in the examination process to get to that point with engineers versus surveyors is when an engineer gets a PE license, the engineer is responsible to understand the rules, laws, nuances, et cetera, of that jurisdiction that they're licensed in. Whether, they start in Tennessee and then they get the license, Virginia or Florida or wherever, they have that responsibility. And in the surveying examination world, every jurisdiction wants to make sure that every surveyor has. Well, I gave the example in that discussion that being licensed in multiple states, if I go to a state and practice, for example, and I may not have practiced there in 2 years, I'm still licensed there, but I now have a job there, a project, and I go do that project. Well, before I release my map, I make sure and go back to my standards and make sure that I'm meeting what I'm supposed to meet. Well, that in effect is what the engineers do, but the surveyors are not doing that. So we're asking a surveyor at the 11th hour to basically kind of look in and see that there's some rules. And I really think that goes back to the discussion we had earlier on the problems that we have with our complaints is lack of knowledge. I think that foundation of simply saying, hey, look, this license is a privilege, it's not a right. And I think that's the key difference in this whole mindset, is that so many people think license and now that's a right for them to move forward. But privilege with responsibilities in my mind. You've earned it through examination, experience, et cetera, and then you have responsibilities. And it's those responsibilities that we continually at this board here have issues with our licensee. It's because they're not taking those responsibilities serious to get into the laws and the regulations and know what they're supposed to do and then perform appropriately. So anyway, you can read that. That's just kind of a thought. It's not a complete thought, but I got a few positive views on it and I was pleased with that. But it's probably something that's actually the next step with the PS as opposed to the current step. I think because what I'm seeing is we're probably going to go ahead and proceed with the CBT conversion of the PS examination, and then maybe this may be the next hurdle that we end up approaching. I've also submitted this same document to the surveying task force, future surveying task force. That's a group in NCWS that is trying to figure out where surveying's going, how it's to be promoted to get more people involved, and how jurisdictions can become more, let's say, uniform, so that we have a better consistency across the jurisdictional boards in everything we do relative to law. That's kind of where that's at.
Okay.
But like I say, I've thrown it out to both committees for that. The other thing I wanted to touch on, just so that, I think we have to make a motion about this, and we probably need to do it at this meeting. Donna, we have a NCWS Board President's Assembly in February in Atlanta. Board President's being the chair. And I'd like to make a motion that Mr. Northcott go to that particular meeting. So you could go ahead and, be doing the travel arrangements and all that type of thing, because if we wait till the January meeting, it ain't happening. February 7, 2015, it's in Atlanta, Georgia.
In that case,
We need a second on that.
we need a second
My
on
bad.
this one.
Second. Didn't realize the motion was made. Second.
All right. Second made. Any further discussion on sending the board chair to the meeting in Atlanta, president's meeting down there for NCS? All right, all in favor?
Aye.
Opposed? I guess I have to get my lead to Atlanta, don't I?
The two other meeting items coming up are, the Southern Zone this year will have a joint meeting with the Western Zone. It's May 14th through the 16th in 2015 in Scottsdale, Arizona. So just FYI for you, Donna. And then the annual meeting, is gonna be in Williamsburg, Virginia, August 19th through the 22nd. Again, FYI, and act on the zone meeting in January. So,
How long are we under contract with NCWS?
it's an annual basis, isn't it, Donna? Don't you pay the fee annually?
We pay the fee annually. Contract, I think it,
I don't know if we have one for the fundamentals anymore.
No longer have that one.
That'll be for some other discussion, but anyway, you know what I mean, so. But, all right, anything else, Tim?
That's pretty well the gist of the EPS committee, and if anybody, after you look through this stuff, has got any questions or anything, just give me a shout or email or something, and I'll be glad to get you the information. If I have it, if I don't, I'll get you an answer.
Okay. Item then, going into some new business. And with new business, I have the TAPS committee reports, and then Mike, the floor is yours. Haven't been sitting over there very quietly all morning.
Holding my tongue, I know. TAPS was asked to come up with standards of practice involving GPS, both static and RTK. I hope you all got the letter from Mr.
I didn't get it. It's on the iPad. Thought I made a copy of it though.
We went over our committee went over this and looked at several states and such, from Kentucky standards. The Kentucky standards were pretty much what we saw as most like what we would need here. They were simple. They kept things didn't go in depth into GPS and the standards of practice of using GPS, mostly because of the changing, evolving of technology of the GPS systems. They were wanting, NSPS came up with, had guidelines as to what should be put in for standards of practice. But again, it was kept very simple. The Kentucky standards indicated that they should have a note stating what portion of the boundary, or if all of it was done using GPS, and what type, whether it was RTK or other. Wanted a note on plats that show the relative positional accuracy or vector closure. I think that was one statement that was made earlier about having standard closure statement, an accurate closure statement instead of just the 1 in 10,000 standard. Or how you would calculate that with GPS, but using the equipment and using it, knowing how to use it and use it efficiently by taking multiple shots at different times over time periods, using static. All things that we looked at in trying to come up with some sort of standards of practice for our. Also, the surveyor should also keep standard documents, adequate documentation on his equipment and how it was used, if it ever came to question. Mr. Stump, surveyor out of Crossville, had come up with some more extensive guidelines. He was on our committee. And they were all more of how the GPS is used, times when, number of shots, things like that, how to detect what would affect GPS as a whole in the all of that's in this letter. If you've got any questions, I'll try to answer them if I can.
Just a little history why this thing came about. From my standpoint, I have a concern that if today, if we talk about a surveyor that has surveyed with a transit and a chain, and that years ago, and any of us as surveyors went out and retraced that survey today, and let's say we were just simply using total station. Well, we would be able to understand and be able to involved in that work and be able to retrace and replace with that methodology.
Mm-hmm.
Now, let's move forward. If we move forward, and let's say today that one of us did a GPS survey, a boundary survey using GPS. The question bodes in my mind is 20 years from now, how does that same individual retrace what we did? Now, where I see that as being problematic is that I'm going to use RTK as an example. RTK, in my limited knowledge, and there's a lot more people that know more on this board than I do about it, but my limited knowledge is an individual point that has its own specific additional accuracy. And that is relative to how that's taken. For example, if I occupy this point for 2 seconds and I push the button, I've got one thing. If I occupy this point for a minute, I've got something else. If I occupy it for 10 minutes, I've got something else. Now, obviously, we all are aware that, in the static observation world, you're getting a lot more data. You can run an Opus solution. You can come up with a very good conclusion to shot. But my concern is the use of RTK in boundary surveying. A good example of that is if you take let's say you take a property corner, whatever it may be, an iron rod, a rock, whatever it may be, something that you could occupy. You do handheld, you're going to get one result. You do RTK, you're going to get another result. You do Opus, you're going to get a third result. Well, in the scenario of describing whatever you think you did, doesn't necessarily allow the future surveyor to recreate that.
That was one thing that we put in there about putting on the plat or on the drawing an indication of what type of GPS was used, both the kind of equipment, the relative accuracy of it, what methods we used, whether we used RTK or static. other type of method. And so if you put that on the plat, on the survey, then, and also keep documentation of it, whether electronic or paper. Keep documentation of what we used, how we did it, the type of equipment, the brand of equipment even. Then in the future, if someone came along and tried to retrace it, they would know, say, okay, you know, a GPS, and it was old and early in the stages, so we can expect a little less accuracy. Trace that a little better, just like we would use.
I think that the concern here, and again, is our standard in our, let's say, conventional standards of practice relative. This is something that doesn't fit into that mold, per se. So, when we did our standards of practice, I was very emphatic about making sure we got GPS language in there. And have it in there, and it's under GPS control surveys, and I think it's under remote sensing also, as I recall. So, it was very important that we got that in there. Now I think we're analyzing a little bit different animal when we're applying that to boundary surveying. And I feel like that if we apply GPS to boundary surveying, then I think probably needs some additional specifics relative to what you all have already suggested, because your suggestion basically falls within what is already in the standards of practice for those other particular areas. But having said that, my concern is how are we going to wrap our arms around that in a boundary survey? Because I don't think it's appropriate to say that I'm out here on the side of a mountain somewhere and I'm only required to have 1 in 5,000 closure with my EDM, and I'm now only required to have the same kind of closure with my GPS. I don't think we're comparing apples to apples.
That's right. With the GPS, personal experience using GPS, you can use it at different accuracies. For example, the other day I was counting stumps. Of course, it wasn't you don't have to be to 100th on location of a stump. If you're within 10 feet, you're okay, and so you can use GPS with a float and still take a shot. Now, it has to be, if I was shooting a corner, then I would probably take it and make sure that I was fixed. I was had accuracy of 2-3 hundredths, and got my accuracy down right, and then take multiple shots on that one point, and then take the best shot or average them, because every shot you take will be a little different. The amount of time you spend on that shot, the amount of time you occupy that position, is going to increase the more time you want to put in. Something where you are required to take multiple shots over a certain period of time, and Mike Stump even suggested over hours or days to reoccupy that point 2 or 3 times, just to make sure, and other little things that you want to make sure when you set your base up, you want to check into another known point as a check. Just some standards there that are good practices in using GPS.
I think what you're saying is the key to the whole situation, Mike, is proper knowledge and practice of utilizing the equipment is going to get you to where you need to go. For example, went on a project just recently in my area, and the gentleman that had surveyed it presented coordinates on the project. Well, they looked like state plane coordinates and they smelled like state plane coordinates, and when I showed up, they weren't within 5,000 feet. So that's the whole thing is, as we gravitate forward into this geospatial world that we're all now working towards, is that very concerned. That's an excellent example because he did not report how he come up with those whatsoever. So when I show up, I said, well, I can take his coordinates here, which I'd taken it and punched it in as you would in any other boundary, but that just happened to be some extra data. So I show up and I said, well, I can start finding the first couple of corners. Well, when I turn the unit on, I am not even close to the job. So, that goes out the window. And that's part of it, and I'm somewhat concerned, well, greatly concerned about the public from a standpoint of their perception is we all use GPS and we can all show up and tell them exactly the latitude and longitude of their corner everywhere we go. And, certainly that's not exactly the case. And they get that because they've got GPS in their car. They've got GPS on their smartphone, and a world where there's an awful lot of data that's presented that people think it's because it's numbers, it's right. And that's where my concern about our profession presenting numbers to the public and the public being able to wrap their arms around, not exactly understand what we're presenting, but wrap their arms around the fact that what they got is real, and the surveyor's the guy that gave it to them. And I don't think we're presenting that across the board to folks, and I think that's another reason why this question is asked.
Well, I think we do need to address the necessity of the confidence that the public can expect in the surveyor using this equipment. The fact is that the equipment now is pretty much another tool in most everybody's toolbox now. I don't think that the current certification that we have addresses it at all. There are surveyors out there using single vector RTK shots on property corners and putting a certification. Licenses, and to come up with some kind of certification that would allow or benefit and protect the public as to what the surveyor is stamping towards. Because right now that doesn't exist if they're out there. How can we do that to best protect the public? And I think this is a great start. I like Rob Sanders' suggestions on there about how we can, or at least the factors that need to be addressed in a new certification. I think that's great. I think there's a couple add to it or massage a little bit. Maybe some of it isn't necessary, but I think it's a great.
Letter from Rob
Letter.
Sanders, yes, ma'am. I just received that by email yesterday afternoon, and I printed it and brought it and gave it to y'all.
Yep.
So, you're right, Jay.
I wonder where, I thought that
Yeah.
Mike had done it, but
No, I dropped that off.
that's
Yeah,
good.
he sent that to me. He knew that we were gonna be meeting and talking about this, and so he sent it to me and also all the committee members. He's on that committee also. So, you're right, Jay, he makes good points. My notion is to back to the committee, and ask them after we conclude discussion, and ask them to formulate something in the spirit of what you were talking about.
Yep.
Because I think that we kind of got a new creature here relative to our standards, but we do speak to it in our standards, and I think it would be easy for this board to adopt something and send out to the registrants in the state and simply say, if you are using GPS to do boundary survey work, da-da-da-da-da, these are what the board feels is appropriate to do. This is a certification you should have on your map, et cetera.
Yes, I also think that just like as we started using total station instruments, GPS simple and to the point that it can evolve with the technology as the technology becomes better. We don't try and limit it, otherwise it will be changing it again in the not too distant future.
I do think it's important that if a certification is drafted up, that it does not suggest or mandate ways that the surveyor goes about doing the survey himself. Rather that it states only factual or statistical information about the tools that were used in order to outcome his opinion.
Like I say, I think that what we have under our geodetic control surveys falls in line pretty close with what you gentlemen suggested, which is great. That's a good thing. That means we're getting on the same page. Again, I still have issue with RTK, because you got single, all these different scenarios that you've got. I myself am not as comfortable with an RTK boundary location as well. More comfortable, for example, if you used GPS and did static observations on traverses and worked off of that for boundary location, that type of thing. I'm very comfortable with that. But again, that needs to be reported. It needs to be reported so that someone else will know how you got about what you got. Again, my example is if it's GPS today and everything's gone 5 years from now and somebody is coming back to resurvey that, obviously knowing as much about what happened the last time is good, but they've still got to be able to have some confidence in where they end up putting that final corner. What we do, we render an opinion on where those writings say that certainly don't want to have, I don't want to perpetuate the pincushion effect that we have had for many years with property corners with the current equipment that we have by going to the most advanced tool in our toolbox and making it worse. That's what I don't want to see happen.
Leave a little leeway in there. Leave a little leeway in the rules, a little wiggle room, but try to put the facts down on.
Thing, Mike, that you saw just today in the rule hearing process thing that we made, state is very concerned about the small businessman, either the single practitioner or the practitioner that only has 2 or 3 folks that work for him. So that's how come that in our standards of practice that we maintain the very lower, in my mind, ratio of precision, was because we were kind of tied with that in case somebody had equipment that's the best they could do. So, this is a different situation. This is, in my mind, a specialized tool in our box. It's an expensive tool in our box, but it's also a highly technical tool in our box. So I think we just need to be able to address, if you're fortunate to have this equipment and use this equipment, this is where we're at.
One thing that was discussed is make sure that the surveyor knows how to use that equipment. Tips, tricks, methods of taking shots. Sure that the surveyor can understand the accuracies and using those tricks to get the best or something better, as good or better than what other equipment can give us. I want to micromanage using GPS within our standards.
We get to a point where we sometimes, or at least those in our profession, feel like we over-regulate, and I think we need to just set a standard, and then how they achieve that standard with their equipment. That's their bailiwick. That's what they've been given a license for. They make those decisions as to how they go about doing that.
And you know, this board, to my knowledge, has yet to have a complaint relative to GPS, and I'm sure that we will. That's why we're trying to be progressive. You know, that's why we were progressive to put them in the standards for that equipment, and that's why we're trying to be even more progressive to wrap our arms around how our registrants are now using them too. But again, not to over so that the future surveyor can recreate.
Okay, anything that we need to do concerning any of this that we have discussed?
Back to the committee and have them bring back in January another recommendation relative to maybe possible certification, et cetera. Is that where I'm getting the gist of it?
Yep. Yeah, first draft of it, yeah. That'd be
Okay.
great.
This is where we've gotten so far. We haven't really drafted a specific rules yet.
Yep, good start.
Okay.
Good start.
All right, and I have one other item here, and that's the NCAAS annual meeting and report.
Before we get there, Mr. Chairman, if I may, I wanted to ask Mr. Roberts, since he's representing TAPS, there were also two other issues that we discussed the last time and mentioned to Mr. Cleveland when he was here. Those two issues, Mike, were, one was a survey report or a report of survey, and Jimmy indicated he was going to form a committee to look at that. What we had suggested was the North Carolina language where, for example, if you go out, if I asked you to come to my property and just simply stake the right side of my property, and that's what you basically do. You come out and find an iron pin on each end and do whatever you need to do to verify it, and then put wooden stakes online so I can build me a fence. Currently, as you heard earlier in a complaint, we don't have a plat requirement. So not having a plat requirement, you may choose to not create any documentation in that scenario. So what North Carolina does in that scenario is they have the surveyor prepare a report that he gives to his client that basically says just what he did. You know, he surveyed the property, da-da-da-da-da, so on, gives that to him. So they actually have a product for the service that's provided. Or the surveyor has the option of creating a plat, even though it may only show one line and a few reference points, et cetera. He has that option. So we had spoke to Mr. Cleveland about the possibility of TAPS looking into that from a committee basis to see if they felt that was a product that maybe our registrants needed to be producing in this state.
I do recall something about that coming up at our board meeting, and I think there was a committee looking into that, but I haven't got any report back.
The other item was the possibility about surveyors being the source for legal descriptions on basically, new work and things of that nature. In other words, not to interfere with the attorneys on anything that's already out there, that's already existing description, but any kind of new work that surveyors do. In other words, cutting out an acre out of a farm or something. The surveyor would be the one responsible for writing the legal description.
I agree totally. I do not recall anything being said at our board meeting about that. I'll bring that up with our next. I'm wholly in agreement with you that surveyors should prepare the legal descriptions as opposed to attorneys or I do know that I think current law allows the landowner to make up his own. But the survey is not required. But I would, as far as legal descriptions, we see so many different vague descriptions, tree to tree or whatever, bounded descriptions as I call them. And we see so many of them. Requirement that says that surveyors should make the legal descriptions and are the only ones to make legal descriptions. But We'll see if, I'll bring that up at our next board meeting and see if we can get something, a committee going on that.
I also mentioned to Mr. Cleveland the other day, we're probably going to revive our photogrammetry GIS committee also.
Yeah.
Thank you, Mike.
Thank you.
Okay. Now that we've covered all of that, anything else that we need to cover concerning and with TAPS? If not, shall we go to the who has it besides you and Jay and everybody? Jay.
I do?
Yeah, congratulations.
Wow. I can just give you a personal review of my experience. Of course, it was the first one I've attended, and it was everything that it was led up to be. I can tell you that. It was with a lot of anticipation. I look forward to going out to Seattle and attending the annual meeting. It was certainly talked up to be big, and it was overwhelming, to be quite honest with you, in a positive way. Just an amazing collection of individuals from 50 states, but all over the world, quite literally. But 66 boards, some great educational opportunities, certainly great hand opportunities, getting to meet a lot of people, names that certainly I've read about and read of, and opportunities to meet with them and kind of exchange. Probably the most assuring thing was that most of the other boards are experiencing very similar outside of that, beautiful city. Wow, great people. Wonderful opportunity. Certainly want to thank the board and the state for allowing us to attend it, and but just a wonderful opportunity. It's certainly looking forward to next year's. That's for sure.
The other thing is that we hit it at the only time that there was good weather out there.
Oh yeah.
And that was a plus. So, and I have to agree with Jay. I thought that this one was in St. Louis and the other places I've been, you just all overwhelmed at what all is there and what really is going on to protect the public and overall protect our profession and to enhance our profession. And this board that's doing that, but it's every board across the nation, and they're working in concert. Differences, but for the most part, we have common issues that we work for, common solutions, and I do like what's going on with the model law and what have you. That gives everybody the opportunity to take a look at standard across the nation at some point, but there's a lot of work that goes into that, and I was blown away again for about the third time that I've been. So, and Tim has been a lot more than that. So I'm forward to whatever the next one will be. All right, let me tell you, I think we've covered our items here with the exception of going through these applications. And what I'd like to do is, if it's okay with you guys, that let's take a break for lunch and then come back and we'll do our applications. We don't have very many, do we? Seven? Okay. And then we'll
Okay, thank you again, Mike.
Thanks, Mike. Do I have to read the notice again? No. We're good on that? Okay. I want to welcome everybody back to the Board of Examiners for Land Surveyors board meeting for today, the 23rd of October. We're back in session after a good lunch, and the only remaining item on the agenda for this afternoon is the review of the exam applications. So we'll be going through those here one by one.
Actually, Mr. Vice Chair, sir,
Yes, sir.
we probably have two other items on the agenda. One is that
Have we?
photogrammetry committee that we wanted to discuss. The
That is
chairman
true.
wanted to discuss it. And I had one question for Ms. Mulder. Do you know if the letter was sent to the agencies and the legislatures about Public Chapter 881?
I have that highlighted too.
I do not know.
Would, in your travels this afternoon, while we're still here, ask Rob and see if
Rob,
that's
yeah.
been taken care of, because that was on last time's agenda as an item that was supposed to be taken care of, yes.
That was for me
Yeah.
to do. I sure didn't do it.
We be ready?
Okay. Ready for applications?
Yep.
All right, first one.
Let's just do them one at a time here and go
Yeah.
through these so we don't have very many. And
And be sure you turn
We
them
can-
down right on one side. See it?
Do you have to do that now?
I did just to.
So you approve all pictures, don't you?
I didn't do my part. He might have.
All right. Well, if you mind asking. That's his
Yeah.
company, that's Bruce's company, isn't it?
Yep.
Does them pretty well, I bet.
Really? Well, that was nice since I was 95.
Where's our sheet? Probably didn't because you emailed all of it. Why don't you go get us some?
That was quick.
It's not as quick as you thought it would be.
But were you successful in your endeavor? I didn't think so with the look on your face.
When I crossed the river, the traffic is stopped going to Trinity Lane.
Oh, my gosh.
I mean, I got over the left lane, came back across the river, back down 8. Here I am. There you be. So,
Do you want us just to prove over here?
Yeah. Or, you know, whatever.
Wherever you want to. Sure?
Yeah.
Okay. Well, I'll look again just to make sure.
and coming across the bridge, coming around the south and west loop, it's backed up clear to the Memphis split out there.
Is there a wreck or construction?
I would think it's probably construction up there. I don't know. I don't, when, do you go that way when you go home?
No matter, no, I go Ellington Parkway.
Ellington.
Pictures. That was Richardson, so he's okay.
Who's the next one? Harris?
Doing them one at a time, we're gonna pass them all the way down.
Why not?
I just signed mine on when you're signing your name, just sign my name.
Okay.
Sue approves pictures.
Let's approve them all.
Good, I'm
I'm
gonna say,
approving them
you
all.
gotta give her the picture. Give her the picture. Aye.
I know, see? Nice and beaching.
Sidekick today, Mr. Cole.
She's getting called up. She's been out.
Scan all that stuff.
Well, there were some, there were.
Beat it down.
Thank you so very much. Blue book. Well,
Trust y'all.
he's got a. Tennessee,
Where is that at?
over in East Tennessee. Crochet County.
Never. I don't believe I've ever heard of Gadsden.
Under high school. Okay. Just sign it.
That's all I'm gonna do. Do we all have to sign it?
Right here. He's got an associate's degree. As coursework, as best I could tell, he took a Survey 1 class and a Surveying 2 class. The rest are all directly civil or physics or trig or to that effect. About 6 months, best I could tell. In fact, I think on his list here, where he lists his courses, unless I missed it, he lists the Surveying 1. But he's applying under 10-year. Is that right? Or is it
Associate
2-year?
degree.
Excuse me, okay, my bad.
Of which 30 hours.
30 hours, isn't it?
He got,
Unless he
has-
spent 30 hours in class.
He lists 4 hours here under Surveying 1, which I mean, he lists Surveying 2 here, but let's that here. Again, the Surveying 1, 4. Surveying 2 is 4. At 8, based on his transcripts of direct surveying coursework.
Where's that law again, Donna? That whole law? One you brought me this morning? I don't know if I... Got it here, Donna. I got it. I got it.
Okay.
I got it.
Would you make me a copy of that before we leave today, that law?
Okay.
Was it in there? I did not look in there. In the very back.
Surveying sciences.
Okay.
The record of 4 years progressive experience and 2 years.
30 hours of board-approved
I didn't want
coursework
to
in
take
the
it out of there,
surveying
but-
sciences.
This is what I did. I went back to our course form. These classes, because they were in the course. 4, 16, 19.
Yep. Required 30, was it?
Mm-hmm.
Yeah.
Now, survey 2, he doesn't have on here.
Well, even if you give him the 4 hours of survey 2, he's still short.
He's still short.
He's at 23.
Yeah.
The rest of them, psychology, materials, structural, yeah.
Whole thing, huh?
That was what, that was my take.
Yep.
Because I think he had the experience, in the 4 years,
I'll get a,
progressive experience, because he was started in 96 doing all this stuff.
That's correct.
Good everywhere else except his shortage on his education.
Yep.
That was my take.
What is is it?
Oh, no. Is this the law that was just recently passed?
Yeah, it's in there.
You'll need to,
62,
when you do.
Okay.
36109.
Here.
Book is not, his wasn't. See,
Yeah.
yours is
Well,
no, yours is the old law.
I don't need that one.
So I'll email you.
I wanna be updated.
Going down there, you want to pass down to Galen? He can start on this.
Sure.
Get a blue folder.
Hey, thanks. Pass one to Sue.
No, I'm not looking at it.
Sue, look at the pictures. I found it interesting, he didn't have a reference form from his father, and he worked for his.
That's the PS.
That's a conflict
In
of interest.
'03. And has never taken the.
Get out of here.
Having a reference from your father,
2012.
don't you
He,
think?
he probably took,
Yeah.
I don't have his hard
That's what it
file,
says,
Whole
conflict
file.
of interest.
but, he's taken it several times. It's been a while though.
He's from Jackson,
He was
Tennessee.
one of the old ones that we allowed to take the whole
Carol,
test at
Carl,
once,
Jason.
and he only
Cal-
passed the P.
One that went earlier, I don't think I initialed.
Oh, that's fine.
It's okay.
And this one.
Looks young, but he was born in 1970.
Carmack didn't have what you were talking about, Tim, reference what?
From his father.
From his father, I was kind of surprised
Oh.
about that.
Maybe,
It's a
maybe,
conflict
like,
of interest.
Yeah.
maybe that's what
We
Sue
don't, I
said.
don't approve that stuff.
I mean, I didn't give a reference form to my son on purpose.
Yeah.
I'm sitting on the board. Too good on the board, you know,
Yeah.
but he's not on the board.
Right.
Frankly.
Unless he's Galen's son, he needs help, right?
Yeah. Which one of these forms you want us to sign? The one in here?
This one.
Just this one?
Yeah, because this other guy didn't have one, that's why.
Which one you got? Carmack,
Carmack,
Galen?
yeah. Uh-uh.
Yeah, I approved him.
Thank you.
Next. Parks.
Do not know him.
Well,
Who's he work for?
well, I'm looking. Residence is on Pisgah Road.
Mm-hmm. It's on the eastern part of the county.
Getting a degree from East Tennessee State.
East Tennessee. Parks, uh-huh.
Checking to see what comes up.
Barry Taylor. Marion Young. Well, let's see here. High school, Tennessee, went to Tennessee Tech. "24 hours." Course-wise at Tennessee Tech.
What are the specs under applying under number 2, the BS in 24 hours?
24.
He's got a biology degree and a master's in water resource management. No, he's Carson Newman and Wisconsin.
Okay, that's what I was wondering. There we go, thanks. And all of these hours have to be what category?
Sparks was BS plus 24, which is category. He has to have 24 hours,
How about
18 of which has to be in
1, 2, or 3?
1, 18 has to be in 1, and the remaining 6 can be in 2 and 3.
Well, 4, 7, 10.
Experience is the issue I've got. Now, the guy that filled this out,
16.
Harville, 39 years of experience. I think that's supposed to be 12. Probably supposed to be 12, I think, in
Right.
total. But he says he is the applicant's PS supervisor.
6.
But he doesn't acknowledge, well, first he didn't
9.
seal it, and then we don't know that he's actually a PS.
Right.
Without that seal, we don't know.
He needs 2 more hours. Okay.
Doesn't have experience under a surveyor. Now, here's the one surveyor he does have. Total of 10 months.
Right.
Hmm. Yeah, that was his experience with Little John Engineering.
Yeah.
You know, if we were sitting there.
He's got the education. Good gosh, he's been in the classroom.
Well, when you look at it, humor me, when you look at it on the basis of
Bother me. It looks like it's all entry-level classwork in terms of the survey. The wording on what the 24 hours needs to be.
I have to agree with you then. He lacks 2 hours having enough to do it in category 1.
Science, engineering, or technology.
I'm going to do that.
4 more years late for the prices.
other courses from his undergraduate that would go into probably category
Tennessee
3.
Tech.
But that doesn't.
Just needs to have that.
18 hours must be equivalent to courses. Basis to stand on right there.
In other words, list 1 is your junior, senior.
Back to you for it.
Did you do Sparks, Galen?
Yes, I did. That's,
Okay.
I handed those back to you.
Galen, look over that one. I'll look over this one.
This in here too, and
Yeah, that.
that right there. Next. Okay, let's see. Guy is absolutely disapproved.
signed it yet.
That's all we need, right?
How are those pictures looking?
Good.
Any good ones? Anybody wearing a wife beater this time?
says.
Yes, 36 hours.
He's from East Tennessee State. You pass him.
Okay. Yes, ma'am. Taylor. Sinful license in Tennessee, Tim.
Yes, sir.
Wonder why he stamped this with his North Carolina embosser.
It's hard to tell sometimes.
He's what?
Hard to tell about Matt sometimes.
Leroux, huh? Okay.
See where my straight sheet went. Sparks, well. Right, his problem is, he's not graduated. He's not ready.
Tim, with 36 hours, how many in category one does he need? 10?
18.
All of them, 1 and 2 both need 18.
His situation is, I happen to know this young man. Progress.
Yeah.
So until he gets those hours, he's not ready to go.
Yeah.
Everything about him is fine.
Yeah.
And I think he'll make a good surveyor, but it's just the fact that he's in progress.
Gotcha.
He's probably 6 weeks away from having them.
Oh, no, I agree.
We did, but we don't now.
Not now.
So once he gets his
Most of these,
Once he gets his hours,
yeah.
he can apply. He already has a degree.
Yeah, look, for example, LaRue and Straight both can reapply in January, and they'll be fine.
Yeah.
They'll be fine, because because when they finish that up, they've got everything they need. So those two, this one and this one are okay straight up. The others lack other hours, so they're gonna have to figure out how they're gonna get them, or do something different, or what. Talking about these applications when we get through them is and you only get 24 hours out of 30. Past, that's what we've done. We've sort of helped them dumb things down.
Although he says he received a degree.
That's just a certification. Just a certification. They have a,
Online,
yeah, it's a certificate program, yeah,
like Wisconsin.
yeah. And that'd be good to put that in there. Well, it's nice to put their name in there, but I think it's for the others. So we approved 3 and denied 5.
Yeah.
Sue liked all the pictures.
I did.
There's that.
Thank you.
You want to sign it too? You can be the fourth one.
Yeah, I think we've got that signed, Gavin. Yeah, we done got that signed.
It only takes two. You signed this,
Yeah,
but,
we're good.
but we
No,
don't
we're
have to
good.
sign the front one.
No, we're good.
Think we don't need to? We don't need to. I ain't doing it. I ain't doing that.
All right, doing it.
Okay.
3 and 5. Okay, just a couple of things about while we're on the application review.
While we are, yes.
One is, I think that when we discussed it before, that we want to hold to this form that we already have in place for our categories, what used to be known as category A, B, and C, which is basically BS, BS 24, and BS 36.
Yeah.
And that gives us a guideline for evaluating their coursework when they submit it. The other thing is, I kind of feel like that we need to discuss this situation about somebody that doesn't qualify under one category, but they can qualify under another category. For example, example I used a minute ago, a BS in anything and 36 additional hours. About how we want to handle that is whether, do we make the decision, in other words, if I apply BS plus 36 and I do not meet that standard and the board turns me down, then I reapply the next time for high school plus 10. Is it my emphasis on me as the applicant to make that revision in my application and reapply, or does the board take the purview of saying, well, this person qualifies under high school, but they don't qualify under BS plus 36?
However, their record shows they did qualify under another category, probably the high. Personally, I think that's the right thing to do.
Okay.
Although I see the value and the merit behind the applicant qualified under, or applied under a certain category, we should hold them to it. I see the merit behind that. But I do think that if an applicant is qualified, then they're qualified. And if they showed in the record that they have those qualifications, such as a high school diploma in the 10 years, qualifications are there, although they may not have checked the correct box in terms of the qualification. The fact of the matter is that if they were to reapply again 6 months later down the road under a different category that they did qualify for, assuming all the ducks are in a row, they would be approved then and would end up taking the same difference as a time frame of a couple months. I just think it's to their benefit as an applicant. I think it's to our benefit as the board, is to give them the benefit of the doubt if they have the qualifications, period, under any of the 4 categories, that they are qualified. I just think we should give them the benefit of the doubt. But the evidence has to be there in the record.
Right, and obviously, if we're dealing with someone in the example I mentioned, we're dealing with an educated person.
Yes.
You know, and that's what the premise that we had in '03 was, that we wanted individuals with a Bachelor of Science education.
Right.
It's just, unfortunate that there's other doors
Yep.
that are available for them to go through
Yep.
to get to the same place, already having that education.
Yeah, that's right.
So, I mean, that was the one thing I wanted to do, was clarify that if the board feels like that we need to reanalyze an application because of a different scenario,
Sure.
because something's lacking in the scenario they started with,
Right.
then we need to do that.
Yep.
And I don't disagree with you at all. I just want to make sure that, you know, as we do that, before we put that final no on that application, we've looked at another option for them.
Yes, yeah. And I think it's
I think
upon
that's
us
a
to
fair.
do.
I just want to make sure we're harmonious on that, so that, you know,
Yep.
as we look at these things, we try to find every available option.
Oh, sure, yeah.
I mean, I think it's only fair.
Having said that, do we need to relook at
That's
any
what
of
I'm
those
thinking.
applications?
That's what I'm wondering.
I think we do.
I think so too.
I think there's two of them we need to relook at.
Yeah.
That's why I really wanted to address that, because I didn't want to let those get away and something be problematic if we agree to relook. Five of them we turned down? We need to look at all five of those again. And on the other business, just changing the subject momentarily, we need to discuss that. Donnie, you get one too.
Yeah.
But this one,
Jump in there, Mr. Sparks.
And we're looking at
Background form that is completely blank.
this one doesn't have. He's not graduated. I think we're right on that.
On this one. You find anything? Man.
He's got 156 months.
seems to have it here.
We gotta relook at this guy.
I don't
Do
see,
you have the experience?
I don't see experience.
Which one are you looking at?
He's
The
the
one
one
that
with
has
the
a
master's.
master's degree.
He's got the master's, but not enough upper level coursework.
He's not showing any experience at all. Coursework. I think that one's as.
It'll be 5. 'Cause I
Five
feel
is
so-
high.
Five, is that what we're calling it?
Yeah, 5 is high school. The little V.
Under little V.
Gonna let you go with them now.
Let's discuss this committee on licensing GIS. Put together a committee to give us some kind of recommendation, and after having talked with Jerry Taylor, Jerry, I think, misunderstood what we were looking for. He thought we were waiting on wanted, and that's not the case.
No.
And I said, Jerry, looking for an answer that we wanted. We are looking for ideas and your feeling as to statement back to me was, we don't need to license technology. I said, no, we don't. We need to license the use. And then meet us face to face and give their recommendation to us. Tim, next.
Well, it goes back kind of to what Jay mentioned in our minutes from our last meeting, on Mr. McDonald's report. NCWS, which I think he misstated about that, because NCWS has a photogrammetric section. Also mentioned that he had mentioned to me in an email that that our statutes didn't support it. Well, just as we went through the chapter we're updating today, it clearly says that we test on photogrammetric methods. So not only does it say that, but it's also in our definition, and it's also in a couple other places in our standards.
Yeah.
So I think we have a foundation to be involved in that area. And I think that the committee needs to go back and relook at that with those items, even if it means we need to kind of start all over. Again, we're not looking for a board answer. We're looking for an answer that the public can live with.
Yeah.
So I'm very much in favor of asking them to kind of, as the old saying in East Tennessee goes, lick the calf over.
Reconvene, and frankly, the committee did not ever meet. Work on it. I think they ought to sit down eye to eye with this particular thing. And halfway between and what have you, but I just think
Well, I guess since I kind of formulated the committee, do you want me to try to put together an email or something and send it to you and Jane Lee? That way just to make sure that, I get everything said I need to, or whatever.
yeah.
Okay.
Could have been as we could have gotten on that committee.
Well, I feel like they're a very good cross-section. That's what I was looking for.
Yeah, that's kind of what I'm saying, but it just.
I think I'll try to, if it's all right with y'all, narrow the charge. Let's just narrow the charge. That may have contributed somewhat because the gentleman, Mr. McDonough, that chaired it is a GIS. That may have complicated it somewhat.
Could have.
So see if we can narrow it back to one topic and realign a little bit and
Hope he wouldn't get the idea that we are not considering ever license.
That's correct. That's correct.
Because that, frankly, I think that one probably is maybe more urgent than photogrammeters, but it doesn't matter with me which one we take first.
It's definitely more broad-reaching, the
I
GIS
guess
is than the
maybe
photogrammeters. Photogrammeters it's a pretty consistent small group across the United States.
On that. Anything else?
Have you had time to check with Rob about that letter?
No, I haven't.
Okay. While you were gone, Mr. Chairman, I asked about, there was a letter that was supposed to be sent to the governmental agencies and the legislatures about Public Chapter 881 that we discussed at our last meeting.
Oh, okay, yeah.
And Donna was not aware of whether that has been formulated or sent, either one.
I'll check with him and get back and email y'all or something.
Okay.
Or we'll do it next, the general next meeting or. It's January
Oh,
22nd, correct?
Our next meeting, yes, ma'am.
Yes.
Yes, one other thing, since this is a one-day meeting, or continuing ed hours for this meeting. Hour.
It doesn't matter how long the meeting is, as long as if we deem that what we did was. Basically, today, we've got 1, 2, basically 3 hours today is basically what we got.
Yeah. That's all I see.
I'd like to make a motion for our meeting today, October 23rd, 2014. We get 3 PDH credits.
Discussion about it? All in favor?
Aye.
Okay. In that case, I'll adjourn.
So moved.
Okay, second.
A second.
All in favor?
Aye.
Except
Or
Donna.
leave, whichever's appropriate. You can turn the TV off, Donna.
Aye.
Graph on this BS.
I did watch that. What is that? Look at that.